Thank you.
Does that address your need,
Ye-
Mr. Murphy?
Perfectly, thank you.
With that, prepare a proposed order. We'll review it and if it meets with my approvals.
Thank you so much.
Anything else?
Not for me, Your Honor, thank you.
Not quite sure. What I did here is that they're to assess him, do a diagnostic assessment, and I think it's for general mental issues. What comes to mind is I know Human Service Center says our folks at Human Service Center are not trained to do forensic evaluations, either on lack of criminal responsibility.
Yes, which is true. And this is not intended to be a forensic examination. It's meant to address his clinical needs.
All right, thank
Does
you.
he need psychotropic medication, for instance? And if so, let's get him a plan to get his psychotropic medication. Clearly, Mr. Murphy, you're going to want to make sure that the jail will give him his psychotropic medication. There are some formularies and some medicines that they will not give in jail because they are controlled substances and highly likely to be abused or cheaped or shared or any of the like. So work with the jail to make sure he gets the appropriate diagnostic testing and treatment if necessary.
Thank you.
All right. With that, we are adjourned in this matter. Thank you.
Thank you.
Next matter the court's going to take up, State of North Dakota versus Daniel J. Johnson, file 47-2025, CR 224.
I'm sorry. Oh, yeah, sure. I'm taking both. One doesn't work quite right. I'm not sure which one it is. I think it's the full one.
Mr. Fremgen, is this you or is it Ms. Depute?
Ms. Depute is going to graciously handle the rest of this afternoon's hearing for our office.
All right. Mr. Johnson, is that you at the Stutzman County Correctional Center?
Yes, Your Honor.
Can you hear and see me okay?
Yes.
Were you present in court when your rights were read to you?
Yes.
You understand your rights, sir?
Yes.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. You have the right to hire a lawyer. You have the right to apply for a public defender. And if you financially qualify for one, the court will appoint one for you, or you can choose to represent yourself. How would you like to proceed, sir?
I'd like to have representation. I mean,
So you want to hire a lawyer, you want to apply for a public defender?
apply for a public defender, please.
Have you done so?
Yes.
Okay, well, I haven't seen the application form, so I'm assuming that I'll get it in the near future. Tell me a little bit about your income.
I'm self-employed. I'm working right now for a gentleman. I've got a little income coming in.
On average, what do you make a month through your self-employment?
Well, the winter and stuff has been a little slow, but on the average, I'm averaging probably around $500 to $800 a month.
All right, I'm gonna find that you presumptively meet the statute for indigency, so that leaves us with two issues. I'm still wanting to see your application form, sir, and assuming that it's consistent with what you're telling me, I'm going to appoint a public defender for you. The court is required to set bail in proceedings when a person has been arrested within 48 hours of arrest. And so we have two options. Option one, we can move forward and I'll just simply enter a not guilty plea on your behalf. And I'll explain the nature of the charges, the maximum and minimum possible penalties. We'll set your bail and schedule further proceedings. Or I can continue today's hearing until a time where you have a lawyer present, but I will be setting your bail without your input then, because I have to do so within 48 hours of your arrest. You understand?
Yes, Your Honor. Yes, Your Honor, I understand. I do have one question though, whenever you get a chance to ask it.
Well, so first the question is, you want me to continue the case until tomorrow when a lawyer might be
Yes.
present?
No, we can proceed today.
All right, so you want to proceed today without a lawyer is what I'm getting at. That's
Yes.
what I'm hearing from you?
Now I'm confused, Your Honor. I don't understand what I'm being asked. I want a lawyer. I want somebody to represent me, yes.
I
But I don't
understand.
want to, I don't want, yeah,
So
I don't want to be
this-
here anymore. I want out. I shouldn't even be here. Like, I didn't do anything
So,
wrong.
sir, stop
And,
talking. I want to make sure you understand. You have two options. Option one, I can set your bail without your input and I can continue the case until tomorrow. And if your application form comes in and I approve it, a lawyer will be appointed, and then tomorrow you'll appear with a lawyer who can represent you at this hearing. Alternatively, we can move forward without a lawyer today. I'm going to enter a not guilty plea for you if you choose that option, and I will set your bail, and you'll have an opportunity to tell me what you think about bail if you want. Those are your two options. How do you want to move forward?
okay, let's move forward today, please.
Move forward today without counsel.
Yep.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, Your Honor.
And I understand that you've applied and that I
Yes.
have ruled on that, at least conditionally. So that's I'm going to enter a not guilty plea for you when we get to that part, but I want to make sure that's what you want to do. Is that right?
Yes, Your Honor.
All right. The court will find a no involuntary waiver of the right to counsel for today's purposes only, with the expressed understanding that the defendant has applied for counsel. The defendant presumptively meets qualifications and eligibility. The court has explained Mr. Johnson's options, and he chose to move forward today willfully. Sir, have you received a copy of the charging document?
Did I?
Is your name and date of birth correct on that charging document?
Yes.
You have the right to have that document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
Yeah, that's fine. But
The state alleges that on or about May 29, 2025 in Stutsman County that you committed the Class A misdemeanor level offense of domestic violence by willfully causing bodily injury to another person who happens to be a family or household member with the initials EC, and you have two prior qualifying convictions, making it an A misdemeanor in files 47-2021 CR 90 and 47-2022 CR 190. Ms. Depute, are you alleging that EC is an intimate partner?
At the time of the offense, yes.
All right. So you are alleging the minimum mandatory domestic violence offender evaluation and treatment?
Yes.
Okay. So, sir, as charged, this is a Class A misdemeanor. Class A misdemeanors carry with it a maximum possible penalty of 360 days in jail, a fine of up to $3,000 or both. The state has alleged a minimum mandatory penalty because EC is alleged to be an intimate partner. What that means is if you're convicted of the offense, you are required to complete a domestic violence offender evaluation and treatment program. You also would be required to submit a fingerprint sample. Court fees for this type of offense total $325. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a United States citizen, this type of offense carries with it significant adverse immigration consequences. There might also be other collateral consequences for which the court is not required to explain. For instance, this type of offense under federal law prohibits you from ever possessing a firearm or ammunition in the future. You understand the nature of the charge and
yes.
the penalties as I've read them, sir.
Yes.
And again, I am going to enter a not guilty plea on behalf of the defendant because he has requested counsel. Not guilty plea is entered. I'll hear from Ms. Depute on bail. Then I'll hear from you on bail, and then I'll make my decision, sir. Ms. Depute.
The state is asking that bail be set in the amount of $500 cash or $5,000 surety. The defendant has a long history of not appearing before court. To cover the last 5 years, he has 3 failures to appear in 3 different cases in 2020. In 2021, 5 failures to appear in 3 different cases. And in 2022, 3 failures to appear in 2 different cases. I understand the defendant is a resident of Sussex County. I believe he has been for a long time, but notwithstanding his residency does not ensure his appearance before court. I would also ask that the order include the provision that the defendant have no contact with the victim EC identified in the confidential information form.
Sir, what do you want me to know about bail?
Yes, Your Honor. Nobody had pressed any charges in this case. My girlfriend that does live with me, she didn't press any charges. I didn't do anything wrong. The other gal that had reported the stuff that was done didn't report accurately. I hadn't done anything wrong. My girlfriend, like I said, she didn't press charges. I have not received a single piece of paperwork in the mail, or I haven't seen anybody to tell me that I had a court date to go to. So now it's the same officers that let me go came to my house and arrested me on the same thing they just let me go for. And nobody has given me any paperwork or nothing that says that I had a court date to go to or anything. I don't feel that I should even be in here. I haven't done anything wrong. My girlfriend even stated that I haven't done anything wrong. I don't understand why I'm even here. And let alone those other cases where it says that I didn't show up for court. I didn't show up for court because all the paperwork and everything was sent to the wrong address, and I didn't get the mail to tell me that there was a court date. That's why I didn't go to court. It's not that I'm trying to miss out on court or anything. I don't understand why I'm even here in the first place right now. I didn't do anything wrong. My girlfriend didn't press charges. But yet when I'm arrested, they tell my girlfriend that she can call the state's attorney and have the charges dropped. She says, well, if I didn't press any charges, how am I going to get the charges dropped? I don't feel that I should be in here. I don't feel that I should have to put up a bond for this. I don't feel that I should have to be separated or have a restraining order away from my girlfriend. I mean, she's actually my fiance. We're going to be getting married here pretty soon. We're in the process of moving out of our house and everything right now. I mean, I honestly, I shouldn't even have gotten arrested, Your Honor. I hadn't received anything in the mail to tell me that there was a court date of anything. There was nothing that had happened.
Mr. Johnson,
Yes, Your Honor.
looks like there was a declaration of probable cause. The court reviewed it, court issued a summons.
But I never got no summons.
Well,
I'm
stop
sorry, I didn't
talking.
mean.
You're
Sorry.
interrupting me. That needs to stop.
Yes,
So
Your Honor, I'm
summons
sorry.
was issued back in June 9, 2025. On June 25, 2025, the court received a sheriff's return indicating that they had made multiple attempts to serve the summons and complaint on you and were unable to make contact with you. After that, a warrant was issued. That warrant was issued on June 25, 2025, and you are now appearing on that warrant. That warrant is quashed. Now, do you understand how that happened?
Yes, Your Honor, I understand what you're saying. Just like you had said, I haven't seen anybody to contact me. I don't know when they came or any of that stuff. So how come they didn't send me a letter in the mailbox? At least, or call my phone number.
Yeah, they can't serve a summons by mail like that. That's not how summons works. So that needs to be personally served by the sheriff, and that's what they tried, and they were unable to do so. So that's why we're here.
Yeah.
I've entered not guilty pleas, or a not guilty plea on your behalf. I understand
Yes,
that you're saying the facts of the offense are different than what's being alleged. Is there
Yes, Your
anything
Honor.
else you want to tell me about bail?
Your Honor, I don't have a whole lot of money right now. Like I said, I'm being evicted out of my house. I have to move out. The money that I have, I really need that to be able to move or do anything with. Like I said, I'm not trying to be a hassle. I'm not trying to not comply with this. I want this behind me. Like I said, I don't feel that I've done anything wrong. So if you could take that into consideration and just know that I'm not voiding them, and I would have come to the court date like I was supposed to if I would have gotten something, but I didn't get anything. I didn't know about it. Otherwise, I would have been there. So if you could take that in consideration and you could, give me a PR today, I would really appreciate it. And I'll show you that I'll be at the next court hearing and everything like I'm supposed to.
Courts consider
I would greatly appreciate it.
Courts consider the constitutional basis of bail Under Article 1, Section 11 of the North Dakota State Constitution, the court's considered the presumption of release on one's recognizance unless the court has sufficient concerns about the defendant's willingness to appear in court. Here, in light of the prior history of non-appearances, I do have some concerns sufficient to overcome that. So I'm going to require a monetary bail. Bail will be set as follows: 300 cash, or alternative 3,000 corporate surety. Additional conditions: shall not violate the laws of any city, county, state, or nation. I am going to put a 300-foot no contact order in place with EC. You are notified that you've been charged with a crime of violence or threat of violence. Any violation of this no contact order is a separate criminal offense, a Class A misdemeanor, punishable by up to 360 days in jail, a fine of up to $2,000 or both. If the officer believes there's probable cause that a violation has occurred, even if that violation occurred outside of the presence of the officer must arrest you. You shall not leave the state of North Dakota without advance express permission of the court. The sheriff's office is authorized to do a one-time escort with you to the property, to exchange property if necessary. They'll only do that escort between 9 and 4, Monday through Friday. You must maintain appropriate contact with the defense lawyer. You must notify the court of any change of address, employment, phone number, or email. You must not possess or consume any alcoholic beverages or controlled substances except as authorized by a licensed physician. You must appear for all future court hearings and appearances unless excused by the court. Your next court date, sir, is October 15, 2025 at 9 a.m. in the Stutzman County Courthouse. You must not possess a firearm, destructive device, or other dangerous weapon. You must sign a promise to appear in waiver of extradition before release. You must submit to fingerprinting before release. You must fill out an application form for court-appointed counsel before release. You understand the terms and conditions of bail as I've said it, sir?
Yes.
All right, if you remain in custody for longer than 48 hours following today's hearing, you can request a bail review. A bail review doesn't mean a bail reduction. It means that bail can go up, it can go down, it can stay the same. But if you stay in custody for longer than 48 hours following right now, you can ask the court to revisit bail. You understand that, sir?
Yes.
That matter is adjourned. Have a good day.
Okay.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.